Start. On or about 26/6/1998, the respondent filed a civil suit against the appellant for recovery of certain items of jewelry allegedly pledged with him on 2/12/1987 for the purpose of obtaining loan of a sum of rupees 7,000 stop para on the premise that the appellant had violated the provisions of the Madhya Pradesh Moneylenders Act 1934 in relation to the aforementioned grant of loan. A criminal proceeding was initiated against him, which was marked as case of 1997 stop. In the said criminal case, he admitted his guilt stop. A fine of rupees 150 was imposed on him stop. The charge was read over to him, which reads as under full colon para. The charge on you is that before date 29/3/1997, complainant was paid borrowed money to you, but even after that you were demanding interest at 5% stop. This act is criminal offence under section 3 and 4 of Moneylenders Act stop. Therefore, show cause notice as to why you should not be held guilty of the said offence stop. Para. Respondent thereafter, as noticed herein before, filed the aforementioned civil suit before the civil judge class 2 Jabalpur, being civil suit for recovery of the pledged jewelry stop. The said suit was decreed directing the appellant to return the said jewelry, or in the alternative a decree for a sum of rupees 20,000 stop para. Aggrieved by and dissatisfied therewith, the appellant preferred an appeal thereagainst stop. The said appeal was also allowed by the learned additional district judge Jabalpur, holding that the judgment of the criminal court rendered on the basis of the purported admission of guilt made by the appellant was not admissible in evidence stop. An admission of the guilt on the basis of a wrong legal advice is not binding on the appellant stop. The suit was barred in terms of Article 70 of the Limitation Act stop para. The second appeal preferred by the respondent herein has been allowed by the High Court by reason of the impugned judgment stop. The High Court formulated the following substantial questions of law full colon para. Whether the suit filed by the appellant was barred by limitation while the suit was filed within 3 years from the date of demand and refusal by the respondent para. Whether the admission of guilt in criminal case in respect of some transaction made by respondent is admissible in the present case to the extent of fact that there was a transaction between the parties stop para. By reason of the impugned judgment, the High Court opined that the suit had been filed within the prescribed period of limitation, having been brought within a period of 3 years from the date of refusal of the demand to return the pledged ornaments stop. The question number 2 was also determined in favor of the respondent, holding that admission of guilt in a criminal case would be admissible in evidence being relevant to the fact in issue stop para. Mr. Sharma, learned counsel appearing on behalf of the appellant, would urge that the alleged pledge of jewelry having admittedly been made in the year 1987 and the suit filed on 26/6/1998, the same must be held to be barred by limitation stop. No document of pledge having been produced, service of notice by itself cannot give rise to a cause of action for filing a suit for recovery of the pledged ornaments stop para. Learned senior counsel appearing on behalf of the respondent, on the other hand, would contend that In view of Article 70 of the Limitation Act 1963, the suit has rightly been found to have been instituted within the period of limitation. Stop. He also contends that having regard to the provisions contained in Section 43 of the Indian Evidence Act, the judgment of the criminal court was admissible in evidence. Stop. In terms of Section 58 of the Indian Evidence Act, things admitted need not be proved. Stop. The suit filed by the respondent has rightly been decreed. Stop.